Good afternoon. Welcome to the Law Library's Book Talk. I'm Jocelyn Kennedy. I'm the Executive Director here at the Harvard Law School. Today's talk is from a professor who has engaged with the issues of law, technology, and copyright his entire career. And I mention that because those issues are very close to us here in the library. Today, Professor Lessig, who like most of our faculty wears many hats, will be wearing another one of his hats, that of constitutional law scholar. Before we begin, I want to thank the Dean's Office for sponsoring this event. Please continue to eat your lunch throughout the talk. And please note that today's talk is being recorded. It'll appear on the law school's YouTube channel next week. We're here to talk about fidelity and constraint, how the Supreme Court has read the American Constitution. Its author, Lawrence Lessig, is the Roy L. Furman Professor of Law and Leadership at Harvard Law School. Prior to returning to Harvard, he taught at Stanford, where he co-founded the Center for Internet and Society, and at the University of Chicago. He clerked for Judge Richard Posner on the Seventh Circuit Court of Appeals and Justice Antonin Scalia on the United States Supreme Court. Lessig is founding board member of Creative Commons and serves on the scientific board of AXA Research Fund, a member of the American Academy of Arts and Sciences and the American Philosophical Association. He has received numerous awards, including a Webby, the Free Software Foundation's Freedom Award, Scientific American 500 Award, and Fast Case 50 Award. Cited by The New Yorker as the most important thinker on intellectual property in the internet era, Lessig has focused much of his career on law and technology, especially as it affects copyright. His current work addresses institutional corruption, relationships which, while legal, weaken public trust in an institution, especially as that affects democracy. Professor Lessig, I think, will be available afterwards to sign books if you'd like, and the book is for sale outside of the room. So without further ado, Professor Lessig, thank you so much.
Thank you, and I'm grateful to the library and the law school for hosting this event and the free lunches that are involved. But I have to say that I wasn't grateful when I recognized just the challenge that I had in presenting this book in the context of a relatively short talk at a lunch conversation. This is a book that literally I have worked on the whole of my career as a law professor. My first article was the first inspiration for the core of the argument of, or one corner of the argument of this book, and it burdened me for many, many, many years. And then I realized that if I didn't get it out before this current Supreme Court did all the damage it was going to do, then the theory I was articulating was going to seem ridiculous because it might not make sense of the court going forward, even though I think it makes sense of the court in the back. So I forced myself to get it out. As you can see, it's 50,000 pages long, this book. They've made it really tiny print, so it doesn't seem that long. There's a ton of stuff in it. There's many mistakes, I'm sure. But I'm going to try to distill what I think are the core lessons for how we should talk about the Constitution or think about the Constitution and suggest a couple implications of that on the way to trying to get to questions. And I have some lunch up here to eat as well. Okay, so I offer this as a theory of constitutional practice in America. So it's a theory to account for something the Supreme Court has been doing. And I want to say that that practice has involved two kinds of fidelities. The ordinary fidelity, the one we think of when we think of fidelity, is a fidelity to meaning, a fidelity to what the words of the Constitution mean and how do we carry that meaning into effect. But a second fidelity that I think is critical to identify and to reckon in the course of constitutional history is a fidelity to role. But simply, like, how does the institution of the court, build the capacity to be a court or protect the capacity to be a court for the purpose of articulating what those words mean? How do you make sure you have the authority to do what you want to do as a court? And I think we need to think about the history of constitutional law by thinking of these two things together. That these two things together define a certain kind of practice of the Supreme Court. These two fidelities together are what we understand constitutional history to be. Now, sometimes these two fidelities work against each other, sometimes. Sometimes they work with each other. Sometimes they complement each other. But we should think about fidelity to meaning subject to fidelity to role. The practice is to try to do what you can to succeed in fidelity to meaning, but you are constrained by role. Okay, so let's start with what I mean by meaning, and then we can talk more interestingly about role. So the motivation I have in the conception of meaning is a particular way of understanding how meaning is crafted. We understand that sometimes meaning in the Constitution seems simple. So for example, Article 1 says that nobody can be a representative who is not 25 years old or 25 years of age. That's pretty simple, it seems. We seem to know what that means. But other examples are not so simple. If I say to you, meet me in Cambridge, while in Boston, Massachusetts, that evokes one sense, while in London, that means a very different sense. So if you want to be clear about that, you need to say something different in London from what you might have to say in Boston. Or if you say, Richard Branson went to public school, that means one thing when uttered in Britain. It would mean a radically different thing if uttered in the United States. So to understand how to say the same thing in these two contexts, you have to understand how to render these two statements differently in these two contexts. So this starts with the obvious point that meaning is a function of context and recognizes that when context changes, we have to at least track how our explication of meaning should change. So if we try to think about how to represent it graphically, if this is a text and we imagine the context and understand that in time two the context is different, how should that affect our reading of the text? And one way to suggest it could affect it is if we have a context in text and then R stands for reading, changing context might lead us to have a different kind of reading as a way to accommodate the change, or you could say neutralize the change brought about by the change in context. And the practice, the intuition that I suggest is behind this effort to neutralize change is what I call translation. Practice of translation is the practice of taking words from one language and rendering them in a radically different way with the objective to preserve meaning between the two contexts. That's what I think this practice is about. But it's a deeper sense of translation. It's a more general sense of translation that I want to invoke here. It's a translation to preserve meaning, but maybe more importantly, to neutralize context as a way to keep meaning alive. Okay, so here's an obvious example. It's a wonderful case which seems completely unproblematic to us today, but was a really critical case in the evolution of civil rights in America, United States versus Classic. This case is grounded on Article 1's structure for electing representatives to Congress. Article 1, Section 2 says that the electors who select members of Congress are the people who would be qualified to select representatives from the largest branch in the state legislature, so that means voters. But Section 4 describes the place where they exercise their power as, quote, elections. So what does election mean? Specifically, is a primary an election? Because the thing about an election is, once an election is done, you know who an officer is. But a primary doesn't select an officer. The primary selects somebody who's allowed to run to become an officer. So if the primary doesn't actually elect someone, is a primary properly an election? Now, the Supreme Court answered this question in case Newberry versus the United States and said, no, a primary is not an election. And what that meant was Congress could not regulate a primary because Congress only had the power to regulate elections. And so what that meant is that in the primary, you could have things like the white primary, which would not be subject to federal law, because it's not an election for purposes of federal law, at least if it's run completely, quote, privately. And that's what the fight in Texas was about when Texas was trying to defend their white primary. And in the case of United States versus Classic, it was a more crude effort to exclude African Americans, where in the primary, basically black votes were thrown away. The federal government tried to prosecute that by saying that's voter fraud. Their defense was, you have no authority to regulate voter fraud in a primary because you don't have any authority over the primary. Under Newberry, that was true, and in Classic, the court reversed it. And it's the methodology the court used in reversing it that I want to emphasize here. The court says, we may assume that the framers of the Constitution in adopting that section did not have specifically in mind the selection and elimination of candidates for Congress by the direct primary, any more than they contemplated the application of the Commerce Clause to interstate telephone, telegraph, and wireless communications, which are concededly within it. To decide this case, we turn to the words of the Constitution read in their historical setting as revealing the purpose of its framers, and in search for admissible meanings of its words, which in the circumstances of their application, should say today, will effectuate those purposes. That's the structure that I'm elevating as a general method the court is adopting. Hence, we read its words as the revelation of the great purposes which were intended to be achieved by the Constitution as a continuing instrument of government. This is translation. You read, quote, elections to accommodate what is not an election from the standpoint of the sense of the meaning of that word, but you do it because of fidelity to something more fundamental in your understanding of what the Constitution was trying to achieve. And I want to suggest this is the practice of the Supreme Court on both the left, what we think of as the left, and on the right. So the most famous example of translation like this on the right is the fight about so-called federalism in the Supreme Court. At least according to the Federalist, or the modern Federalist, maybe not the original Federalist, the Constitution presupposed a certain balance in regulatory power. It imagined there would be some power in the federal government, but most of the power would be held in the states. But the original rule that articulated the scope of federal power in Gibbons gave a formula for federal power that said that the power would include activity between the states, interstate commerce, activity in one state that affects other states, the effects component of interstate commerce, an activity that doesn't go between states or doesn't affect more than one state, but which is necessary to regulate in order to regulate number one and number two. Okay, when you add those three branches together, the consequence of that formula is that it may have been limited federal power back then, but the power is a function of the nature of economic integration. And as the economic integration of the nation grows, the consequence of that is congressional power grows. Now, as that happened, at first the court just ignored it, even though there was dissenters that said, hey, wait a minute, we're destroying the Federalist balance here. But eventually the court came around to trying to correct it. And what I want to say is we should think of that effort at correcting as a kind of translation. They were crafting limits on Congress's power in the name of a founding value, what they viewed federalism to be. These limits were made up, like they're not in the text. They're just kind of made up rules for saying Congress can't regulate here even though it can regulate there. So for example, they said there's a difference between direct and indirect effects. Or they said commerce is not manufacturing, which is true, but under Gibbons, you should be able to regulate manufacturing if it helps you to regulate commerce. But the court said, well, forget all that. We're going to create these made-up limits in the name of fidelity to a framing value, which is the value of federalism. And if this is justified, and I agree, this is a huge if, I don't want to presuppose anything here, but if it is justified through this thing that I'm describing as a kind of translation. Example on the left, maybe the most understandable, is the example that comes out of Olmstead versus United States. So Olmstead involved this guy who was a police officer and also one of the most important criminal syndicates of illegal prohibition. It was a case that was built on wiretapping. The officers, federal officers and state officers, but prosecution involved the use of wiretaps. The wiretaps were affected by basically connecting an attachment to the wires of the telephones as they left Olmstead's home. So that means there was no need to trespass in order to wiretap Olmstead's conversations. The Fourth Amendment prohibits unreasonable searches and seizures, and the understanding of the context within which that prohibition exists was searching that involved trespassing. So the idea was this prohibited or limited your ability to trespass on someone else's property to search or seize, and you needed either a warrant or you needed an effort to justify after the fact that it was reasonable to do that. The government said wiretapping involves no trespassing, so there should be no limit on our ability to wiretap. And Chief Justice Taft said, yeah, you're right. There's no violation of the Fourth Amendment when you wiretap because there's no trespassing when you wiretap. So if there's no trespassing, there's no trigger for the application of the protection of the Fourth Amendment. But Justice Brandeis in dissent gave us a conception of the Fourth Amendment, which is directly a conception of translating the scope of the Fourth Amendment. What he says is, what we have to do is to read the Fourth Amendment, the adaptation to a changing world, so that it's in effect protecting the same scope of our privacy as it would have protected in a world where the only way to penetrate privacy was through trespass, in effect, translation. And 40 years later, in the case of Katz versus the United States, authored by the law clerk Larry Tribe, the Supreme Court eventually adopted this reasoning in crafting the scope of privacy, not on the basis of trespass, but on the basis of reasonable expectations of privacy. So this is, in a sense, a translation. That's what it should be understood to be, I think. And the law then should see this as a translation too. Again, it's a made-up limit on the scope of government's power, not in the text, if in fact the text is as the Fourth Amendment said, and if it's justified, maybe again a big if, it's justified through something we could call translation. Both of these cases then, there is a value that is preserved. The context has been neutralized, no doubt imperfectly, always imperfectly, but arguably better than doing nothing, at least sometimes, if indeed fidelity is the objective, fidelity to meaning is the objective you're trying to evince. Okay. But this translation is obviously difficult. It's institutionally difficult. As the gap grows between texts and application, and as the values that you are translating become more contested, the pressure on the translator, the court, grows. Sometimes it grows slowly over time, increasing resistance. Sometimes it's not as slow a growth of the resistance. And so in both of these cases, the question the court needs to ask is, what do we do in the face of this increasing resistance to our translation? So in the context of federalism, 1929, of course, was the moment of the Great Depression. That Great Depression triggered an extraordinary range of changes, many had nothing to do with economics directly. Thurman Arnold describes, when institutions function adequately, the theories which support them also appear to be adequate because they are never called upon to solve practical problems. The very success of the institution prevents anyone questioning its underlying theory. The lack of faith in the future is not caused by specific legislation or the advocacy of specific objectives. It is the failure of practical institutions to function which has raised doubts in the heart of conservatives, practical institutions that were producing a growing economy, and all of a sudden the economy had collapsed. He says, 20 years ago, no one worried about socialism because it was, now he's writing this in 1939, so it's not today we're talking about, but 20 years ago, no one worried about socialism because it was thought to be impossible, just as water running uphill is impossible. Automatic economic laws prevented it. Today we see before us both fascism and communism in actual operation with their governments growing in power. Economic law no longer prevents such types of control. The only bulwark against change is the Constitution, but with the disappearance of the economic certainties, the actual words of the Constitution no longer appear like a bulwark. So the point is, as this reality makes us increasingly uncomfortable with what we think about the world around us, it becomes increasingly difficult for the court to resist the charges of people like Franklin Roosevelt that the court is acting on the basis of their personal economic predilections, not on the basis of the law. And Roosevelt worked very hard to render the court political, to render them partisan, by saying that their judgments were judgments motivated by political values, not by the certainties of the Constitution. So as the court becomes rendered political, the question the court needs to ask is not just what's true, not just what does the Constitution, fidelity to meaning, require, but increasingly, what can we do? What can we, the court, do? How much can we continue to do in the name of carrying into effect our conception of what the Constitution requires? The question becomes, do we stick to the truth, federalism, or do we yield to the pressure that says that give up this fight in the name of federalism because this fight is not one you will win? 1937, the view is the court yielded, Jones and McLaughlin is that case where the most dramatic shift happens. 4 years later, Darby seems to confirm it. And then a year later, Wickard, as we look back on it, seems to double down in the confirmation. But what's incredibly interesting about the history of Wickard is the untold part of the history of Wickard. So Wickard involved this guy, farmer Filburn, who wanted to grow wheat on his cattle farm to feed his family and some of his cattle. This wheat was never going to travel off the farm. It was going to be consumed on the farm. It wasn't sold to anybody. And so when the government tried to tax him because he was growing more than he was allotted permission to grow, he challenged it as saying it was beyond the commerce power. And the question the court had to answer is homegrown wheat that is neither commerce nor interstate, indeed it's intra-farm, exist within the scope of the Congress's commerce power? The court, of course, said it is, but what Barry Cushman has shown us is that, in fact, the court struggled mightily to reach that conclusion. And there's a period of time where it looked like Jackson was going to write an opinion striking the law down. And so as he describes, Jackson eventually comes to a recognition that in such a state of affairs, he says, in a memo to his clerks, bizarrely, the determination of the limit of Congress's power is not a matter of legal principle, but of personal opinion, not one of constitutional law, but one of economic policy. And what that leads him to say is that if this is just economic policy that would determine the limit between federal power of commerce and private power or state power of commerce, then economic policy is inappropriate for us to be determining. And if it's inappropriate for us to be determining it, we should withdraw from this determination, even if we believe, as I think a majority of that court believed, that Congress had gone beyond the scope of Congress's commerce power. So fidelity to meaning would have said one thing, but fidelity to role led the court to step back from articulating that meaning. And that fidelity to role, I'm going to say, is a fidelity to the fidelity to role. As the court was rendered political, it finds a way to retreat, or at least when retreat would be rendered political, it decides not to retreat. This is another more recent example. I'm sure all of us are familiar with Planned Parenthood versus Casey. The extraordinary joint opinion in Planned Parenthood versus Casey is an excellent example of this fidelity to role analysis. The court decides not to overturn Roe, even though probably one, maybe two of those justices certainly would never have voted for Roe originally. And the court explains this by saying, in the present case, however, as our analysis to this point makes clear, the terrible price would be paid for overruling. The court's power lies in its legitimacy, a product of substance and perception that shows itself in the people's acceptance of the judiciary as fit to determine what the nation's laws mean and to declare what it demands. On the principled choices, thus, the court's legitimacy depends on making legally principled decisions under circumstances in which their principled character is sufficiently plausible. We have to be able to see them as principled to be accepted by the nation. The court must take care to speak and act in ways that allow people to accept its decision on the terms the court claims for them as grounded truly in principle, not as compromises with social and political pressures, having, as such, no bearing on the principled choices that the court is obliged to make. So here the court's saying openly, we need to decide this as a function not just of what we think the Constitution means, but also as a function of how we will be perceived in deciding that case according to what we think the Constitution means. And we will be perceived in this case as a bunch of justices appointed by Republican presidents for the purpose of overturning Roe versus Wade. And so it will be seen as an attempt to amend the Constitution outside of an ordinary way of amending the Constitution, which will undermine the legitimacy of the court. Thus, even if it was originally wrong, which I think to a majority of the justices Roe was, reversing because of politics weakens the court. This is fidelity to role. And a critical implication of fidelity to role is that the obligation of fidelity to meaning remains. There's a continuing obligation to translate, even if we can't do it right now. So even if we can't now, because of context or contestation of the politics, or because we haven't developed the right tools, even if there's no legal tools or no public will, still, if later the tools emerge or the public will revives, then we should revive the objective to translate that original meaning. So the court did that. It tried it in National League of Cities with the Federalism fight. 9 years later, it retreated, discovered again this was too difficult. In Lopez, it tried to do it again with the Federalism fight. Gonzalez versus Raich, homegrown marijuana, basically gave up, retreated. The Obamacare case is a really elegant effort to continue the Commerce Clause fights. Not clear when or whether there will be a retreat from here, but the point is this ongoing obligation to translate remains, and the only question is, can you craft the right tools to achieve it given the context and the political character of the time? So in federalism, the pattern has been something like this. There's an original understanding the Federalists say, there's a translation of that, there has been a retreat and a revival, and this has been repeated, this cycle of retreating and reviving and retreating and reviving as the court continues to try to advance that purpose. I'm going to just make a very brief signal towards the other really important example of this, which is the Civil War amendments. So as you know, the Civil War amendments evinced a commitment to change not just the law, but the culture of America. It was a deep commitment to transformative constitutionalism. And as you also know, that change stalled, or that change was stopped by white terrorism across the South. That basically made it impossible to carry into effect the fundamental commitments that Reconstruction had hoped for. The great hope of Reconstruction was, in this sense, I think, killed. Between the period, it's not a sharp line, 1877. I think there's lots that's going on in the Justice Department after 1877. But in the political space, basically 1877 to 1954, the court can be read to be retreating. The Constitution's meaning, original meaning from the 13th, 14th, and 15th Amendments are increasingly suppressed. We could say the founding values are betrayed. There is an infidelity to meaning in this period. But it's because of a certain kind of fidelity to role. I want to resist here the idea of these evil judges doing terrible things while good America wishes them to be doing the right thing. I want to recognize here what we had is an evil and racist America that was constraining the judges. Not that they were all enlightened, but they had a very clear sense of what they could never get away with, how far they could never press this constitutional meaning. Until, maybe it's ironic, I don't know, but until the most evil, Hitler in World War II, and a fight about racism in Europe, made equality possible in America again. Because after World War II, the question was raised, indeed before World War II, Southern racists said we shouldn't fight Nazism in Germany because then what would that imply about racism in America's South? So they said, stay out of that war because it's only going to come back and bite us. And so that's exactly what happened. After that war was fought in the name of ending racism in Germany, in America, it was no longer plausible to continue to overlook the deep racism in America, and that triggered the revival of these values in 1954 with respect to race, and then from 1967 on, a translation of those values with respect to sex and sexual orientation. So if this is federalism, this is what the equality looks like. We have this original value, this aspiration of transformative constitutionalism, an immediate retreat, or practically immediate retreat, a revival of the original values in this period, 54 to 67. 67 is when the end of anti-miscegenation laws happens, and then translation from 67 on to reach other values beyond race. Okay, one final point that I want to stop, because I wanted to stop 5 minutes ago. What are the sort of core lesson here? So I think that we need to think more systematically about how constitutional law lives within certain kind of constraints. The one we focus on so much is text. I think we have to unpack more effectively the constraint of context. And the context here includes us, and I mean specifically us as in elite legal actors, but not just us as in elite legal actors. I mean like a culture as a whole. Our beliefs, our expectations, our understandings in a critical way constrain the court. Sometimes that constraint enables fidelity to meaning. Sometimes that constraint resists fidelity to meaning. And so in a certain sense, we too become part of the Constitution. This constraint becomes part of what the Constitution is, regardless of the texts. What the Constitution is always defined by the possible of what the Constitution will be allowed to be given that constraint. And this is, in some sense, I think, all that really ever matters. This is the product of 25 years of work, that all that really matters, in some sense, is this constraint of us in the project of constitutionalism. It's a kind of populist constitutionalism, then, that I want to defend as an account of where we've been. Obviously not often great, indeed often quite awful in what it produces. But in some sense, it's our only hope if this is the nature of the Constitution we have crafted, and it gives us a path forward. Because I believe that if we build an understanding in popular culture of what the Constitution needs to be, without even amending the Constitution, if we build it, then the court will eventually come to it, regardless of the text, and despite the political predilections of those justices individually. Okay, that's all I'll offer, and eager for your questions or thoughts. So I guess there are mics that are going to go around, or? Yeah.
When I was an undergrad a long time ago, I read a book called Government by Judiciary, and Raoul Berger was actually arguing that that the justices of the Supreme Court were really wildly reinterpreting due process and privileges and immunity, especially with regard to voting. So would you consider, he's arguing for fidelity, I guess.
Yeah.
So when you say that they're going back to the Reconstruction people weren't really saying what the Supreme Court did with regard to voting,
Yeah.
or even with regard to Brown versus Board of Education.
Yes. Well, I'm going to bracket Brown for a second, because I think the other point you're making about voting and privileges or immunities is directly on point to what I'm arguing. So as I try to develop in the book, I don't think the interpretation the court makes in the slaughterhouse cases, and then later in the voting rights cases before 1950, before Brown, is plausibly understood as fidelity to the meaning of those constitutional texts. It's not. I mean, the slaughterhouse cases, which basically completely guts the privileges or immunities clause, was obviously not consistent with what was understood at the time about what that clause was meant to achieve. But as I try to argue in the book, we can see how Miller, in that context, is trying to avoid the court bearing the burden of articulating what the privileges or immunities will be. And indeed, that opinion explicitly leaves open the power for Congress to articulate through federal law what those privileges or immunities should be, and the court seems to say that it would enforce them. So I think that that opinion and the later voting rights opinions are the same, evinces this sense of them having a very clear sense of how much they can or should go with. Now, the place I would get off the train with Berger, though, is that his conception of meaning is very much like Scalia's conception of meaning. I just describe what I think of as one-step originalism versus two-step originalism. So the one-step originalist says, go back to the framing and ask the question, what would the framers have done with the following question? How would they have answered it? And then take that answer and come back to the present and apply it. So Scalia talks in his paper about originalism, what would the framers say about flogging? Well, go back there, ask them that question, look around. They would say, well, flogging is not cruel or unusual. It's what we do all the time. So the answer is flogging is, in 1791, constitutional. Grab that answer and run back to the present and apply it. Yes, flogging is constitutional. Now, Scalia says, I think I'm a faint-hearted originalist because I'm not sure I would be able to reach that conclusion, but that is the right answer from an originalist perspective. And Berger was similar in the sense that it was one-step originalism. But what I'm offering is translation is actually two-step originalism. Translation says, find the answer in 1791, and then find the equivalent today. And the equivalent might be the opposite conclusion. Might be you say it's constitutional in 1791 and not today, but that's a function of your effort to translate.
I'm curious, what are your thoughts on the ways in which the court has the capacity? Because I liked at the end you talked about how the court, in a certain way, is compelled by we, the people. But what happens when the political process that the court is, tries to steer clear of, appears to subvert the will of the people? I'm thinking in particular about Rucho v. Common Cause, where the court sort of said, yeah, we get that, this is, Roberts even conceded this is crazy partisan gerrymandering, but that's not our field. We can't really step in.
Yeah, so I actually, even though, obviously, I think it's obvious, but my politics are not Roberts' politics at all. I think Roberts is a brilliant fidelity to rule Chief Justice. And that most of the interesting things that he's done, not all of them, I think his dissent in the gay marriage case is just terrible from this perspective, but the Rucho case, the citizenship case, Obamacare case, these are all cases that are only explicable if what you're focused on is the fidelity to role obligations of the court. So in the Rucho case, I think what Robert says this explicitly. Robert says, look, especially in current partisan times, if we took up the challenge that Kagan tells us we should take up, to adjudicate every single jurisdiction and decide which gerrymandered jurisdictions violate the Equal Protection Clause and which don't. When we come down with a decision, we'll give our reasons, citing political scientists and citing Nick Stephanopoulos' great work. We'll give lots of reasons, but the ordinary man, Robert says, he says the, quote, ordinary intelligent man, quote unquote. I don't want to get in trouble for using his words, but those are his words. The ordinary intelligent man will say bullshit. He doesn't say that, but I'll say that. I'll say bullshit. It's not about those it's about the fact that these are Republicans and that's a Republican district they're upholding. And indeed, when you recognize that most states are Republican, and on average they'll probably not all be illegal, they will be upholding mostly Republican states. And so it will fuel this increasing partisan framing of what the court's doing. And so what Roberts is basically saying is let's just stay out of that, because we'll never be able to decide this case in a way that makes clear that it is the rule that's guiding as opposed to our politics. The citizenship case is even more obviously this, right? So the citizenship case where the court basically says that the administrative decision to allow the citizenship question on the census was pretextual is, from administrative law perspective, bizarre. Thomas has a wonderful dissent where he's like, are you kidding me? When has it ever been the case that an administrative decision is struck down because you say it's pretextual? They're all pretextual. Obviously, administrations make decisions for political reasons and then justify them for legal reasons. But he strikes it down as pretextual because he saw this extraordinary evidence that was coming up demonstrating the deep corruption that had gone into the decision to make this decision hang on citizenship and not. And I think he was just avoiding the embarrassment. Indeed, he directly cites Friendly, where Friendly says, we don't have to be blind in a way that ordinary people can see, meaning, ordinary people are going to see this is a completely corrupt political thing that they did. We don't have to box ourselves into assuming that's exactly what it is. So I think he is revealing this consistently, and he gives me hope that this balance can be maintained. Other justices, obviously I'm going to say this about people on the right, but maybe people say the same thing on the left, but I think other justices are less constrained. I know Scalia didn't give a damn about the institutional bullshit. I mean, it's like, no. It's just, what's the right answer from my perspective? And let's just do it if we can.
First, I think it's a splendid book, but I do wonder where you place yourself with regard, say, to Alex Bickle and the notion of passive virtues, which basically I think were institutional constraints, and then Jerry Gunther's critique of Bickle as wanting a court that's 100% principled 20% of the time. Could that be part of an analysis of your work that you really do want a principled court, but it can't be so 100% of the time. Do you have any percentage in the back of your mind?
Yeah, as much as possible. Principled as much as possible. Recognizing that they're going to be cowardly, so they should probably do it more than they think is possible, but as much as possible. And so I completely accept. I think my work is completely continuous with Bickel, and even with the the Harvard Process School. The place that I think I want to add something new to it is that I don't think, a la Hart and Wexler, that what's ultimately constraining here are a set of principles as much as a set of social meanings that are contingently constructed in any particular historical moment. And the reason that's an important distinction to draw is that if you understand the constraint to be social meaning constraints, there's a strategy for changing them. Like if you understand, I mean, the extraordinary history that you and I are covering in our Reconstruction course, Gates's new book about Jim Crow and the late period of Jim Crow. The extraordinary part of that history is the efforts made to construct inequality through the construction of social meaning representations of Black Americans and white Americans that would render them unequal in the public's mind. That was an effort at creating a reality that then the law made sense with. And that effort was self-conscious. It was very much about how do we make these social orders seem sensible given the understanding of the underlying facts. And I think that's how we should understand the current set of constraints that we happen to find ourselves with in the reality of the constraints that I think constrain the court. Because if we understand it like that, then it's like, okay, what would we have to do to change these meanings to make it different? Like some of them we like I'm all for the constructed social meaning around gay rights that produces a court, even a conservative court, to say, hell no, it makes no more sense for the law to draw lines in this way that burden people on the basis of sexual orientation or choices about sexual behavior like that. So that, is a social meaning I'm all okay with, but to the extent there are others that draw the court in a way that I think we would want it to be drawn differently, thinking about it as social meaning as opposed to principles gives you a principled way to think about changing it as opposed to saying, well, principles, we're gonna, we need different principles. So that's a distinction from the earlier work that I think is an important reason to, not to disagree with that work, but to see how to extend it.
Professor Lessig, thank you so much for talking today. You've given a descriptive account of fidelity, constraint, and popular constitutionalism. How would you give a normative assessment of that descriptive account?
Yeah, so I think in a Dworkinian or maybe Davidsonian sense, theory is about fit and justification. So you're right, I'm saying that if you add fidelity to role into the fidelity to meaning account, you're going to have a descriptive fit that's much better than Ackerman's account or other accounts that try to tell the story of constitutional history. The justification for it ultimately ties back to the same point about social meaning. Would you want a constitution like this? Would you be happy to have a constitution that is constrained by this kind of social meaning dimension? And in one sense, the thing about social meaning is it's quintessentially democratic. It's like something that's out there in our minds and can be driven by democratic development or evolution. So in some sense, you would say, I like it for that feature. And the other part that I like about it is given the constraint on amending our Constitution, it is a way to both play the fidelity game and the updating game effectively. Now, I don't like the fact we have a Constitution that can't be amended. I think that's a terrible flaw in our Constitution. There are many, I don't think it's as flawed as Sandy does, but I think there are lots of flaws we can identify in the Constitution. So I'm not saying this is the best of all constitutions, but I'm saying given the starting point of that, I think I would be happy justifying most of the practice that I've described. But if part of the reason of putting it together like this is if you don't like the practice, you don't like the idea that in some sense the Constitution's meaning is a function of what we are all going to be taking for granted in the background of our political culture, then at least it's a way to isolate how how we should go about changing it. That's good too, but I wouldn't be on that side of that argument.
Hi. Thank you for the very fascinating primer to the book, which I will go and read. Historically, you mentioned a number of cases where it seems fidelity to role was the sort of trumping factor in this balance. But have there been times where fidelity to meaning has been the deciding factor? And then sort of looking at it moving forward, do you believe that there are times when the balance should just be tossed out and maybe something is so fundamental to the sort of constitutional makeup that fidelity to meaning needs to hold forth over this fidelity to role?
Great question. So yes, I think there are plenty of examples. So I would say all of the cases of translation where there's this change in the face of what seems to be text to the contrary are examples of fidelity to meaning winning out over fidelity to role. Sometimes it's easy when the result conforms to our kind of taken for granted political views. It's easy. So in 1967, as elegant as Katz versus the United States was, it wasn't terribly surprising. It's not like that innovation, that translation, was institutionally difficult for the court. I mean, of course, it fed the view of the Warren Court as a kind of make-it-up court, but it politically, culturally was not troubling or problematic. The hard question is when you can see the court justices believing, here's what meaning requires, but I know looking around, everybody's going to hate this. They're really going to hate this. And I'm not sure right now I would pick particular examples where I think that they've necessarily done that, because I think constraint of role has been really powerful and overwhelming. So yes, all the time, but not many times where it's deeply costly. And yes, so should there be times when you just say meaning be damned? I hope so. Because I think the ultimate objective is meaning. I think the ultimate objective is preserving a constitutional fidelity to meaning. I think the institution of the court, just has to be aware of how much it can do. And I think it should recognize that, again, as I said, it's going to be cowardly. It can probably do more than it thinks it can do. But it can't do as much as it can do. I mean, I'm glad to see my friend Andras Shayo here, who brought me to Eastern Europe a long time ago when he was running CEU, and I spent a lot of time in that area thinking about the problems there. And we spent a lot of time talking about the Russian Constitutional Court under Yeltsin. And Vladimir Zorkin, Vladimir or not? I don't think it's anyway. Zorkin, who was a law professor who became the head of the Constitutional Court. Terrible idea. Conceived of his role to lecture Yeltsin about the meaning of the Constitution. And he was extraordinarily activist and going out there and declaring all sorts of things unconstitutional. Indeed, one time Yeltsin gave a speech and he went on and Zorkin went on television and declared the speech unconstitutional. Because he believed his job was to bring the meaning of the Constitution into reality. And the only way to do that was to be as. And I remember, because I went there after it happened, Yeltsin sent tanks in and surrounded the court and shut it down. I mean, here's just as blatant an exercise of power against reason as you could imagine. And, taught Zorkin to behave in the right way. He's still on the court today. He's not the chief, but he's still on the court, and he's a completely different kind of justice. But that's an example of going too far, not recognizing you can't take for granted your own authority. You have to construct it and sustain it and develop it. And that's going to be hard to do, even if justices don't necessarily do it enough.
I have a question about sort of when the roles of the Supreme Court operate in tension with one another. Some would say that the role of the Supreme Court is, for example, to protect minority voices. And we see the Supreme Court making a distinction between racially discriminate impact versus racially discriminate intent that ultimately makes it almost impossible for laws that have racially discriminate impact that uphold, in a lot of cases, white supremacy to be litigated through the court. So I'm seeing this sort of tension that arises that the Supreme Court ultimately always chooses the role to protect itself as a branch of the judiciary while giving up the role that a lot of people would say is foremost in checks and balances. And so I'm curious about how you hold when the roles clash.
Yeah, I would hope one could use this book to say, you imagine this kind of therapy session with the Supreme Court, not individual justices, but with the court as a whole. So the therapy session would go something like, okay, look, here's how to understand this way you've gone forward. Like, you're trying on the one hand for fidelity to roll, to meaning, and you feel yourself constrained by fidelity to roll. And in that conversation, I would personally say to the court, you've not been bold enough to carry into effect meaning in many, many cases, and race is one of the best examples of that. The court would say in response, well, you should understand our constraints, you should understand, and I would say, look, you, the Supreme Court of the United States, should not worry as much about your constraints as maybe courts in Eastern Europe or Russia need to worry about your constraints. That would be the conversation, but my point is it wouldn't be obviously wrong what I'm saying or what they have done. It's a beginning of a conversation that's now channeled the understanding in a way that isolates the two problems and helps you test whether you think the role constraint is as real as you say it should be. So I give an account of the evolution of, like, the race cases, both the affirmation of the Brown right and then the compromise in the context of affirmative action and what drives that compromise. And so I think there's no doubt that you could say one part of the thing that's driving that compromise is a blindness of justices themselves, no doubt. But I'm saying another part of it is their appreciation or sense of a certain kind of constraint the culture is bringing to them, driven politically by, Reagan's Justice Department that begins to render that whole effort as political in a way that it hadn't been even under Nixon. So those two things are there. How much one accounts for it versus another is, anybody's judgment. I just want to isolate them so I know which one to work on and how to work on them, given the differences between the two.
Professor, thank you so much for being here. I'm right here.
Oh, right there, yeah.
You began your talk saying that you wanted to get this book out right away because you weren't sure the framework was going to hold up going forward. Can you speak about that just a little bit?
Yeah, I mean, so Jack Balkin ran a really great little online symposium about this, and Sandy was a contributor to that symposium. And one of the themes in that symposium was that a lot of this way of thinking about the court's position was contingent on a political culture that imagined something beyond the partisan understanding of law that we seem to have embedded so deeply right now. And that, and so I think that's true. And at the end of the book, I reflect on, is this even understandable in a current political context where we have so fragmented on partisan grounds in our understanding of the law. And so when I'm confessing my anxiety, it's that if that continues in that way, and you don't have a really effective counter to that, which I'm suggesting Roberts plays that role to some extent, but not enough, then at a certain point, it's just going to seem just like politics completely, not in the legal realist sense or even the critical legal study sense, but in the completely obvious political sense that there's nothing more than politics. Now, I think indeed that's the way the media now characterizes the work of the court. Everything is cashed out in this kind of 4 justices appointed by Democrats, 5 justices appointed by Republicans, or 6, whatever it is. And that only reinforces this sense. And so I was eager to articulate this in a moment where there's at least some of us who still could engage in a discourse that imagined a different world from the one that I think most of us live in right now. I'm reminded again, there's one of the conferences that Shio ran. I always attribute this to you, Andras. You'll probably deny it was you, but there was a wonderful moment where an American law professor got up and he tried to lecture the Eastern European law professors about legal realism. Like, they were talking about law, and he got up and he basically said, there's it's just politics. There's no law. I mean, it's just power. It's just power expressed through law, and this is what legal realism has taught. Critical legal studies has taught it even more effectively. You just need to understand this. And somebody, and I think it's Shio, but again, he'll say no, but somebody responded by saying, you know, it would be a disaster if we thought of law in that way. If judges in the post-communist period thought of law as just politics, we could never enforce civil rights. We could never stand up to the state. We could never have a legal culture that could resist the forces of power in politics. So we need to think about law, not in this legal realist way, but in a more German formalist kind of way. That's why we need to think about it. And what was striking about that is it was an explicit understanding that our way of thinking about law itself was socially constructed, and that we should pick which of the social constructions is actually conducive to the kind of legal culture or kind of political democratic culture that we want. And it was very sharply presented in that post-communist moment, which one they needed. And I think part of my lament in the book is I'm anxious about us walking too far down that line here too, because I think that the court, however flawed, how many mistakes, I'm not praising any golden past, but how even with those flaws, how much good something like this channel of politics is in the context of a democratic republic.
Thank you, Professor. Do you think at times justices inaccurately assess the political boundaries within which they operate? Meaning, is there a mismatch between social meaning and social meaning as construed by the justices? And if there is, what are the causes of that and some of the implications of that for your theory?
Yeah, obviously there's a mismatch. And one of the biggest questions that the book raises is why should we imagine, Jack Balkin's essay basically puts this directly. Why should judges be in the business of social meaning arbiters? They're typically old white men. So why are they, not all of them, but the norm. So why are they good people for making this arbitration? Why shouldn't we look to the political process or something else? And the answer is not that they're good. Indeed, they're not good. The answer is just that they might be better than any other institutional actor. The political process, give me a break. That's another chunk of books that we can talk about. But the political process is no better. And the ordinary, unorganized public is no better because the whole point is reflecting on the consistencies or inconsistencies of social meaning at any one time and deciding what to do about it. The judges are bad because, again, their demographics are wrong and they're not connected as directly. It's good that they have clerks. I think there's an understudied dynamic of the extent to which clerks shame justices into entering the modern age, right? The fact that all these clerks, sort of come from this world and go there and then roll their eyes at these justices is really important. That is a constraint on what they can do. And so I would, again, from the standpoint of if you recognize it's about social meaning construction, then I know the things I should worry about. I should worry that it's the wrong demographic. So therefore, diversity is really critically important in the institution of judges, because this diversity helps fuel the broad understanding necessary to evolve social meaning in the right way. It's about recognizing how age itself is a non-diversity, is a lack of diversity. And you're not going to put 20-year-olds on the Supreme Court. That's a good thing. But at least the justices need to recognize this capacity, this limit in their capacity, and engage in a way that acknowledges that limit. The end, even in the ideal system, again, I don't think it's great. I would only submit that it's better. And if we have a constitution that requires it, which I think we do, then this might be the best place, given all the other places are just so terrible.
So your book has, many principles that you can draw from it that you can sort of look at from a more 10,000 feet level of what is judicially legitimate behavior. What advice would you give to a young democracy, to the court of a young democracy? Sort of what principles would you draw out of here and, impart to them?
Well, I would start with the Star Trek principle that I don't want to affect. I wouldn't give advice. I mean, but one within that democracy who tried to see what lessons there were here, I think it's just a more systematic recognition of the constraints on building the capacity and the authority of institutions of the court. Like, what do you have to do to make that work? And I talk about the Russian court in here and like the problems and the failings there. But a more systematic, I mean, you know, because you were in my comparative con law class, this is a focus of the comparative con law class, systematic recognition of places where ambitious courts have been crushed, and what systematically might have avoided that would be the core lesson that I think should come out of this. I also think that the recognition of the structural failure of our amending clause would be an important lesson from this. I mean, it's a terrible thing we can't amend our Constitution, because what that does is force this into the courts. And it forces us to think about constitutionalism as if it's the thing that judges do. And indeed, when you suggest we should somehow take it and put it back in the people, like when I defend the Article 5 Convention idea, and people are terrified, the idea that you would allow the Constitution to be determined by anybody other than Harvard and Yale educated lawyers, I think that's a way of understanding the pathology that's grown into our Constitution, because it's just not a Constitution if it's not the thing that ordinary people can at least get close to. So I think that one lesson should be the hard line of like how easy versus how hard. There's a Goldilocks problem here, no doubt. But we have like an impossibly difficult standard against the background of a deeply partisan public, which makes amendments almost impossible, which makes all the pressure on the court even more difficult. Somebody's going to say that's it, right? June says that's it. Thank you so much.